Hey there, curious minds. Welcome to another deep dive where we unravel complex topics and distill them into actionable, easy to grasp insights. Today, we're plunging headfirst into the dynamic, intricate world of international business contracts and payment terms. Have you ever found yourself wondering what it really takes to seal a deal across borders?
hmm
Or how a seller in one country ensures they get paid by a buyer thousands of miles away, reliably and without a hitch? Well, you're in the perfect place. We've sifted through a mountain of information from our listeners' sources, and our mission today is to extract every crucial nugget, giving you that aha moment of clarity, complete with surprising facts and those key details perfect for quick recall.
Indeed. International trade is far more than just goods crossing borders. It's built upon a sophisticated, often invisible, web of agreements, legal frameworks, and financial safeguards. What's truly fascinating here is how seemingly small, technical details, like the precise point where responsibility for a product changes hands, or the specific way a payment is structured, can have monumental legal, financial, and even strategic implications for businesses.
Wow.
Our goal today is to connect these dots for you, helping you grasp not just what these rules and terms are, but crucially, why they matter so profoundly to anyone navigating global commerce.
Okay, let's unpack this deep dive. We're talking about everything from the fundamental anatomy of international contracts to the web of national laws, the universally accepted shipping terms, and the diverse, sometimes surprising, methods of getting paid across continents. Think of this as your essential, engaging guide to understanding the very backbone of global commerce, packed with practical knowledge and insights that will make you feel truly well informed. Ready to get started on this journey?
Let's do it.
All right, so let's start at the absolute bedrock of any business transaction, domestic or international, the contract itself. At its core, what is a contract in the eyes of the law? And how does India, for instance, approach it domestically?
That foundational definition is crucial. At its most basic, a contract is defined as an agreement that can be enforced in law. It's not just a casual promise or, a friendly handshake. It's a legally recognized commitment.
Okay.
When goods are sold, both the seller and the buyer have the legal standing to enforce that agreement, which is, well, where the power of a contract lies.
Right.
For domestic Indian trade, our sources make it very clear. These agreements are squarely bound by the Indian Contract Act 1872. And that specific date, 1872, that's a key historical fact, establishing a long-standing and robust framework for legal agreements within India, giving both parties clear legal recourse.
1872, got it. That makes perfect sense for deals within a single country. Everyone's operating under the same clear legal umbrella. But here's where it gets really interesting for our deep dive. What happens when those parties, the exporter and the importer, are in entirely different countries with entirely different legal systems?
Yes, that's the million-dollar question, isn't it?
Exactly. When you have an exporter in one country and an importer in another whose rules apply, this conflict of laws sounds like a major headache waiting to happen, potentially leading to endless, costly disputes if not addressed up front.
It absolutely can be, and that's precisely why clarity here isn't just important, it's paramount in international trade. When both parties are in India, they inherently know Indian law applies.
Right, simple enough.
But across borders, that certainty just vanishes. So the key principle our sources highlight is that exporters and importers must put their terms in writing and critically explicitly specify the applicability of the law of a particular land to their contract.
Spell it out.
Spell it out. This written agreement prevents misunderstandings from the outset and makes dispute resolution much clearer if things go awry. Without it, you're navigating a legal gray area, which is precisely what sophisticated businesses want to avoid in high-value international deals. It's about building a predictable legal foundation for inherently unpredictable global transactions.
So it's all about preempting problems. How does that typically play out in practice? Do they just pick a country at random? Or is there a default?
Well, there are a couple of common scenarios. If, for instance, the physical delivery of goods takes place on the carrier in the exporter's country, then the exporter's country's law often becomes applicable by default, or at least highly influential.
Okay.
However, most commonly, and ideally, parties mutually agree on the applicability of a particular country's law. This mutual agreement is vital because it's about predictability and managing risk.
Makes sense.
By explicitly stating which country's laws govern the contract, both parties gain a clear understanding of their rights and obligations. This makes dispute resolution far more predictable and manageable, reducing the time and cost associated with legal battles down the line.
So a contract can be more than just a formal piece of paper with a signature. Let's clarify the different forms a legally binding agreement can actually take. This feels important, especially in our fast-paced digital world.
Absolutely. While we often think of contracts as formal, meticulously drafted written documents, the legal landscape is actually much more nuanced. First, we have an oral contract, sometimes called a verbal or parole contract.
Okay.
This is a legally binding agreement made through spoken communication, not written down or signed. While legally valid, proving the exact terms can be incredibly challenging, making it generally unsuitable for complex international deals.
Right, hard to prove.
Then there's the written contract, which is what most people picture. An agreement thoroughly documented in writing and typically signed by one or both parties. These are particularly essential for Indian exporters, as our sources note, because they're crucial for securing special export facilities and incentives, providing a clear and undeniable paper trail.
Got it. And then there's this third category, constructed contracts. How do those work, especially without a single formal written document? That sounds like a potential minefield if you're not careful.
You've hit on a crucial point. Constructed contract is particularly fascinating because there isn't a formal, single written agreement, but the contract is inferred and legally established from the documents exchanged between the parties.
Interesting.
This demonstrates how adaptable legal systems have become to modern communication and commerce. Our sources give us some compelling examples of what can constitute a constructed contract.
Sure.
It can be inferred from telex or fax messages, from electronic data interchange, EDI, with authenticity of messages and exchange of letters, purchase orders, or even through letters of credit.
Wow, so emails, purchase orders, they can form a contract.
Potentially, yes. The key takeaway here is that both written and constructed contracts are equally binding on both the exporter and the importer. What's truly insightful is that in our digitally driven age, a clear, consistent trail of communication, even without a formal, single-signed document, can constitute a binding agreement. This can be a double-edged sword, highly convenient for speed and efficiency, but also potentially dangerous if not managed meticulously. It underscores the paramount importance of clear and consistent communication in all forms, as any documented exchange could be legally scrutinized later on.
Okay, speaking of clarity and avoiding misunderstandings, let's talk about Incoterms. This is a term you hear constantly in international shipping and logistics. What exactly are they, and why are they so absolutely critical to global trade?
Incoterms, which stands for International Commercial Terms, are precisely that, a globally recognized set of standards used in international trade contracts. Their purpose is to define, with absolute clarity, the responsibilities of sellers and buyers for the delivery of goods.
So it's like a shorthand.
Exactly, a universal language. This was first established way back in 1936. That's a key historical marker to remember. The current, most updated version, reflecting modern shipping practices and challenges, is Incoterms 2020, and it comprises 11 distinct terms.
11 terms in the 2020 version. Got it. And who creates these?
These rules are not developed by any single government, but are published by the International Chamber of Commerce, ICC, in Paris, a key international organization in facilitating global trade. That's another important fact, the ICC in Paris.
ICC Paris. So they're like a universal dictionary for shipping and logistics. Without them, every international shipment would require lawyers to write incredibly detailed, bespoke agreements on who pays for what, when risk transfers, and where delivery actually happens. This must drastically simplify things.
Precisely. These rules are essentially a universal language, cutting through the potential confusion of different national legal systems, customs, and commercial practices. The ICC created them exactly to simplify and standardize these critical aspects, thereby reducing misunderstandings and disputes between parties from different countries.
Makes sense.
While our sources mention earlier versions like Incoterms 2000 and 1990, the fundamental principles for these core terms remain remarkably consistent across versions, with 2020 being the most relevant today. Understanding them isn't just good practice. It's vital for minimizing costly disputes and accurately costing international transactions.
Let's dive into some of the most common Incoterms and what they actually mean. These terms are vital for setting expectations and, crucially, for understanding where responsibilities, costs, and risks shift. We'll start with the terms that are applicable to any mode of transport, be it road, rail, air, or sea.
Absolutely. Knowing these definitions isn't just about jargon. It's about dictating not only who bears which costs, but also, critically, who bears the risk of loss or damage to the goods at various points in the journey.
Okay, if I'm a seller looking for the absolute minimum responsibility, where do I start? I hear EXW is often cited as the seller's easiest option.
You're right. EXW stands for Ex Works, followed by a named place of delivery. Under EXW, the seller's obligation is minimal. They deliver when they simply place the goods at the disposal of the buyer at the seller's own premises, or another named place like their factory or warehouse.
So basically, come and get it.
Pretty much. From that point onwards, the buyer covers all transport costs, all risks, and all responsibilities. It truly places the minimum obligation squarely on the seller.
So the buyer does almost everything. What's the next step up in seller responsibility? What does FCA mean?
Moving along that spectrum, FCA, or free carrier, followed by named place. Here, the seller delivers the goods to the carrier or another person nominated by the buyer at the seller's premises or another named place. The responsibility transfers a little further along the chain than EXW, as the seller ensures the goods are ready for the main carriage.
Okay, a bit more involved for the seller. And then how do terms like CPT or CIP build upon that, particularly when it comes to costs and insurance?
Excellent question. CPT, or carriage paid to, followed by a named destination. In this case, the seller delivers the goods to the carrier, or nominated person, and pays the cost of carriage necessary to bring the goods all the way to the named place of destination.
So the seller pays for the main shipping.
Yes, pays the freight to the destination, but crucially, the risk of loss or damage transfers much earlier when the goods are handed over to the first carrier.
Ah, okay. Risk transfers early, even though they pay the freight. What about CIP?
CIP, or carriage and insurance paid to, followed by a named destination, is similar to CPT, but with an added vital layer of protection for the buyer. The seller contracts for insurance cover against the buyer's risk of loss of or damage to the goods during carriage.
Insurance is included.
Right. The seller is responsible for the goods until they are handed over to the first carrier, and they must provide this minimum level of insurance.
We're definitely seeing a progression of responsibility and who shoulders the risk. What about the D terms, like DAP? These sound like the seller's doing even more.
The D terms signify a much greater responsibility on the seller, yes.
Yeah.
DAP, or delivered at place, followed by a named destination, means the seller is responsible for the costs and risks of delivering goods to a specific named location at the destination. The risk transfers at that named destination once the goods are ready for unloading.
Ready for unloading. And then DPU, I understand this is a relatively newer term replacing something called deity. Can you clarify that?
Precisely. DPU, or delivered at place unloaded, followed by a named destination, is indeed the most current term from Incoterms 2020. It means the seller delivers the goods at a named place, and crucially, unloads them.
Unloading included.
Yes. Our sources also define D-Day, delivered at terminal, which was the predecessor to DPU in Incoterms 2010. D-Day specified that the seller was responsible for delivering goods to a named terminal and unloading them, with a terminal including places like a quay, warehouse, container yard, road, rail, or air cargo terminal. DPU effectively broadens terminal to any place where goods are unloaded, offering more flexibility.
So the seller's doing even more work. And finally, DDP, or delivered duty paid. This one sounds like the seller takes on the most responsibility.
Indeed, DDP, or delivered duty paid, followed by a named destination, is the Incoterm that places the absolute majority of responsibility squarely on the seller, and consequently, the absolute least on the buyer. Under DDP, the goods are not only delivered to the named place of destination and ready for unloading, but the seller also handles all import clearance procedures, including paying import duties and taxes. This really is an end-to-end service by the seller.
They handle everything right up to the buyer's door, practically.
Pretty much. The entire shift in responsibility and cost, from EXW, where the buyer handles almost everything, to DDP, where the seller takes on the most, perfectly illustrates how Incoterms define obligations. Understanding these isn't just for lawyers, it's absolutely critical for anyone involved in international trade and supply chain management to know precisely who is liable for what and at what point the risk of loss or damage transfers from seller to buyer. It's about managing expectations, accurately pricing, and avoiding costly surprises that can derail an entire shipment or even a business relationship. Hashtag tag 2.2 Incoterms for sea and inland waterway transport only.
Beyond these general terms, some Incoterms are specifically designed for shipping by sea or inland waterways. This makes perfect sense given the unique dynamics and risks of maritime transport. Let's look at those.
Yes. These rules are tailored to account for the specific dynamics of waterborne transport, particularly regarding the precise point of delivery and risk transfer relative to the vessel itself.
Starting with FAS, what does that mean?
FAS, or free alongside ship, followed by the name port of loading. This Incoterms rule states that the seller's responsibility is to place the goods alongside the vessel at the named port of loading.
Alongside but not on.
Correct. Once the goods are alongside the ship, maybe on a quay or in lighters, the buyer bears all costs and risks of loss or damage from that moment onwards. So while the seller is responsible for bringing the goods to the ship, the risk transfers quite early, before the goods are even loaded onto the vessel.
Then the very common FOB, we hear this one a lot. How is it different?
FOB, or free on board, followed by the name port of loading. This is an incredibly widely used term, especially for bulk cargo. It means the seller delivers the goods on board the vessel nominated by the buyer at the named port of shipment, or procures the goods already so delivered.
So the key is on board.
Exactly. Crucially, the risk of loss or damage to the goods is borne by the buyer once the goods are safely on board the vessel. This is a critical distinction from FAS, as the seller's responsibility extends to getting the goods onto the ship itself.
What about CFR? How does that compare?
CFR, or cost and freight, followed by the name port of destination. In this scenario, the seller delivers the goods on board the vessel, or procures them already so delivered. The seller must also contract for and pay the costs and freight necessary to bring the goods all the way to the named port of destination.
Seller pays freight again, like CPT.
Yes, the seller pays for the transport to the destination port, but importantly, the risk of loss or damage transfers when the goods are on board the vessel at the port of shipment, not the destination port. Same risk transfer point as FOB.
Okay, risk transfers early, seller pays freight, and finally, CIF. This one includes insurance, right? Like CIP for sea freight.
Yes, essentially. CIF, or cost, insurance, and freight, followed by the name port of destination. This is similar to CFR, but with that added vital layer for the buyer. The seller contracts for insurance cover against the buyer's risk of loss of or damage to the goods during the carriage.
Minimum cover, usually.
Generally, yes. Under CIF, the seller is generally required to obtain this insurance only on a minimum cover basis, but it's still a significant added protection. The key distinction here, particularly for FAS and FOB, is the exact point of delivery and risk transfer relative to the vessel. For instance, FOB is incredibly common and means the seller's responsibility ends once the goods are safely on board the ship. But with CIF, the seller takes on the added responsibility of arranging and paying for insurance for the buyer's benefit, at least to a minimum level. This offers another layer of security for the buyer at the seller's initial expense, making it an attractive option for certain types of goods or routes.
Beyond the specifics of the trade contract itself and the Incoterms, international trade from India is, of course, shaped by several foundational national laws. How does the Indian government actually fit into what are essentially private export contracts?
This is a crucial point of balance in any sovereign nation. Export contracts are indeed generally private agreements, meaning the Indian government typically does not interfere with their specific provisions.
Okay, hands off mostly.
Mostly. But this non-interference only holds true, provided the contract provisions do not go against various laws enacted for the overall export-import business in India. These laws aren't designed to hinder trade, but rather to facilitate it, protect national economic interests, ensure the quality and reputation of Indian exports, and effectively manage foreign exchange flows.
Right, setting the guardrails.
Exactly. Let's look at some of the major ones that every Indian exporter and importer absolutely needs to be aware of. Hashtag 3.1 Foreign Trade Development and Regulation Act, 1992, FTDR Act.
So what's the big picture with the FTDR Act of 1992? This sounds like a really foundational piece of legislation for India's global trade.
It absolutely is, and its date, 1992, is a key fact to remember. The Foreign Trade Development and Regulation Act, 1992, often just called the FTDR Act, is a comprehensive law that serves to regulate and, importantly, develop foreign trade in India.
Regulate and develop.
Yes. Its main objectives are clear and twofold: to facilitate imports into India and to increase exports from India, thereby bolstering the nation's economic growth. To achieve this, the Act grants the government wide-ranging powers to prohibit, restrict, and regulate exports and imports, both generally and in specific, targeted cases of foreign trade.
And how does this act translate into specific practical policies for exporters?
The government uses these very powers to create and implement what's known as the Foreign Trade Policy, FTP. This policy is more than just a set of rules. It sets the strategic direction and incentives for India's global trade. A key detail here is that the Director General of Foreign Trade, DGFT, which is a significant office under the Ministry of Commerce and Industry, is the primary body responsible for formulating and overseeing the FTP.
DGFT under the Ministry of Commerce. Got it. So the FTDR Act empowers the DGFT to set the rules. What are some of the most practical day-to-day requirements for exporters under this act that directly impact their contracts?
There are several critical requirements that directly impact how an export contract is structured and executed. For instance, if there's a price regulation or a minimum floor price fixed for a particular product by the government, an exporter simply cannot contract to supply that product below that fixed price.
Makes sense. Can't undercut the minimum.
Exactly. Similarly, if a product is officially banned for export, the contract cannot, of course, legally cover its export. And if certain goods are released on a quota basis, meaning only a limited quantity can be exported, it's mandatory for the exporter to include a clear clause in their export contract stating that the supply is explicitly dependent on the release of that specific quota from the government.
Contingency clause.
Right. Perhaps one of those fundamental requirements, and in fact you'll definitely want to recall, is that every single importer and exporter must obtain an Import-Export Code, IEC number, from the Director General or an authorized office. This IEC number is your unique mandatory identifier for engaging in any international trade activity from India.
The IEC number, that sounds like a must-have.
Absolutely essential. The FTDR Act of 1992 is the central pillar here. It's not just about rules, it's about strategic economic management. And that IEC number is a perfect example of a foundational requirement ensuring traceability and compliance. Hashtag 3.2 Foreign Exchange Management Act, 1999, FEMA.
Next up, FEMA, the Foreign Exchange Management Act. What's its critical role, especially concerning money changing hands across borders? This must be absolutely vital for India's financial stability.
Indeed, the Foreign Exchange Management Act, FEMA, enacted in 1999, another key date, is absolutely crucial for managing India's foreign exchange reserves and maintaining economic stability. Its primary function is to permit only authorized persons to deal in foreign exchange or foreign security.
Only authorized persons. Who are they?
These authorized persons, and it's important to remember who they are, include authorized dealers, typically banks, money changers, offshore banking units, or any other person specifically authorized by the Reserve Bank of India, RBI, which is India's central bank. This ensures all foreign currency transactions are channeled through regulated entities.
So it's about channeling foreign currency through regulated entities like the RBI to keep tabs on it. What are the key regulations for exporters under FEMA, especially concerning when they need to get paid?
A critical regulation and a specific time frame you'll want to remember is that the full value of export proceeds must be brought into India within a period of 180 days from the date of shipment.
180 days. That's 6 months, roughly.
Exactly. This is a strict, non-negotiable deadline. Any extension beyond these 180 days requires prior approval from the RBI, unless the exports are genuinely made on a deferred payment basis, or the goods are sent on a consignment basis, which have their own rules. This rule is a direct control measure to ensure timely foreign currency inflows into the country, bolstering national reserves. Furthermore, our sources also highlight that an Indian exporter is not permitted to pay a commission of more than 12.5% to an agent abroad for sales they've made.
12.5% commission limit. That's very specific.
It is. That 12.5% limit is a clear ceiling designed to regulate payouts to overseas agents, again protecting national economic interests and preventing excessive foreign exchange outflows. So under FEMA 1999, remember the 180-day rule for proceeds and the 12.5% commission cap, hashtag 3.3 Pre-Shipment Inspection and Quality Control Act, 1963.
Quality control is absolutely paramount for safeguarding India's international reputation as a reliable supplier. How does Indian law address this to ensure goods meet global standards?
This is precisely where the Pre-Shipment Inspection and Quality Control Act, 1963, comes into play. As its name indicates, it was enacted in 1963, another date to note. The main purpose of this act is to regulate the quality of goods exported from India, thereby actively protecting and enhancing the reputation of Indian exports by establishing robust quality control and mandatory inspection mechanisms.
So it's about protecting brand India.
Exactly. It's a proactive measure designed to build trust and confidence in the global market for goods originating from India.
So exporters can't just ship anything. It has to pass a quality check before it even leaves the country.
Precisely. It is an obligation on the part of the exporter to obtain a certificate about pre-shipment inspection and quality control from an approved agency before shipment can take place.
A certificate is needed?
Yes. While the Act sets these minimum standards, contracts can, of course, stipulate even higher, more stringent quality norms if the buyer requires them. This Act, originating in 1963, is truly crucial for safeguarding brand India by ensuring that its exports consistently meet or exceed certain quality benchmarks, which in turn enhances confidence and strengthens India's standing in the highly competitive global marketplace. Hashtag 3.4 Customs Act, 1962.
And of course, nothing leaves or enters the country without passing through customs. What's the fundamental role of the Customs Act of 1962 in all of this complex web of international trade?
The Customs Act, 1962, enacted in 1962, another key date, is essentially the legal gatekeeper for all goods entering and leaving India. Its core principle is simple but absolute. No goods can be sent out of the country without proper customs clearance.
Makes sense.
This isn't just about administrative paperwork. Customs authorities have the legal power to check all consignment goods. The purpose of these checks is multifaceted. First, to ensure that only the goods stated in the invoice are actually leaving the country, and second, to prevent over or under invoicing in the process.
Why is preventing over or under invoicing so important? What are the implications of that?
That's a critical question. Over or under invoicing can be mechanisms for illegal activities such as tax evasion, where businesses try to avoid paying the correct duties, or even money laundering, where illicit funds are disguised as legitimate trade payments.
Okay. Serious stuff.
Very serious. So, the Customs Act of 1962 acts as a critical bulwark against illicit financial flows and ensures strict compliance with all national and international trade regulations. It's about maintaining economic integrity and national security at the borders. Hashtag #Marriage 3.5 International Commercial Practices.
Beyond these national laws we've just discussed, international bodies also provide crucial frameworks that streamline global trade. Which ones are key here, and how do they interact with or complement national regulations?
While national laws are essential, they can vary significantly from country to country. That's why these international documents are so vital. They provide a harmonized framework for specific aspects of international trade, especially where national laws might diverge, creating potential friction.
Okay.
Our sources specifically highlight two key documents prepared by the International Chamber of Commerce, ICC, in Paris. We mentioned them for Incoterms earlier. First, the Uniform Customs and Practices for Documentary Credits, UCP 1993, and second, the Incoterms, 1990, though we focused on the 2020 version.
And the UCP 1993 sounds incredibly important from the way our sources describe it. They call it the Bible to bankers.
It truly is. The UCP 1993 is often called the Bible to bankers for the negotiation of documents related to letters of credit. That phrase, Bible to bankers, is a really vivid description and a key detail to remember.
Bible to bankers. Got it.
These ICC documents provide a globally accepted rule book that all banks and businesses involved in international transactions can adhere to, fostering trust, efficiency, and a common understanding across different jurisdictions. This harmonization makes the negotiation and execution of complex financial instruments like letters of credit much smoother and far more reliable, regardless of the specific countries or national laws involved.
So we've covered the overarching legal environment and the vital international terms like Incoterms. Now let's zoom in on the anatomy of an export contract itself. What are its essential components, the very building blocks of a successful international deal?
An export contract is, at its heart, a legal agreement that meticulously outlines the terms and conditions for the sale of goods abroad. It has to be incredibly comprehensive to account for all the unique variables of international trade.
Right.
Key elements typically include the precise export price, the agreed mode of payment, specifics about storage and distribution methods, the types of packaging required, the exact port of shipment, and the all-important delivery schedule, etc. These details ensure both parties know exactly what to expect.
That's a lot of detail to get right. Do exporters have to start from scratch and draft a completely new contract every single time they make an international sale?
Not always. Most exporters have wisely developed standard general contracts, especially for common or less complex items like, say, handicrafts or garments.
Standard templates.
Exactly. This approach simplifies day-to-day operations, saves time, and significantly reduces the possibility of overlooking crucial details. However, if the goods exported are highly complex items, such as petrochemicals, specialized machinery, or defense equipment, well, the export contract has to be drafted with an exceptional degree of care and precision.
Tailor-made.
Absolutely. The level of detail in an export contract is directly proportional to the complexity and value of the goods and the transaction itself. For simple, repetitive items, standardization is efficient. But for something like petrochemicals, the financial stakes are so high and the variables so numerous, from specific chemical compositions to regulatory compliance in multiple jurisdictions that bespoke, meticulous drafting is absolutely essential to mitigate substantial, potentially catastrophic risks.
The legal dimensions of international trade are quite broad, encompassing far more than just the basic buyer-seller agreement. Our sources break them down into 4 key categories, which helps simplify a complex landscape.
This categorization is a really helpful way to understand the different spheres of legal risk and compliance within international business. These four categories are, first, those relating to the export-import contracts themselves, which we've just touched on. Second, those relating to the relationships between the exporter and their agents or distributors in foreign markets. Third, those relating specifically to the products being traded, such as intellectual property or liability. And fourth, those relating specifically to letters of credit, a key payment mechanism we'll explore shortly.
Okay, so contracts, relationships, products, and LCs.
Right. It's not just about the moment of sale. It's about the entire ecosystem of international business relationships and product responsibilities. Each category presents its own set of unique legal challenges and requirements that must be carefully addressed. Hashtag 4.2 relationships between exporter and agent distributors.
For exporters looking to expand globally, working with agents or distributors in overseas markets is incredibly common. But this relationship, too, needs its own robust legal agreement, right? It can't just be an informal understanding given the distances and different legal systems.
Absolutely not. To effectively promote and expand in overseas markets, most astute exporters enter into an export agency agreement. This is a truly critical legal document, as it precisely establishes and defines the relationship between the principal, who is the exporter, and their agent.
Okay.
Our sources list several important points that must be clearly addressed in such an agreement. If you're an exporter, these are clauses you should absolutely never skip, as they're vital for clarity and protection.
Let's run through them. What's the very first, most fundamental point to define?
First, the parties to the contract. This seems obvious, but it includes not just the names and full identities of the principal and agent, but also explicitly defines the right, or crucially, the lack thereof, to assign the contract in favor of a third party. Clarity here prevents future confusion or unintended transfers of responsibility.
Makes sense. What about the products the agent is supposed to be selling? That needs to be clear.
That's the second point, contractual products. This clarifies whether the agent is authorized to work for all products of the exporter, both present and future offerings, or only for specific ones. Exporters often prefer specific mentions to maintain control, allow for different agent relationships for different product lines, and maintain flexibility in their market strategy.
Territory must be incredibly important to avoid overlap or disputes between agents.
Indeed, point 3, contractual territory, is absolutely crucial. Without a specific and precise mention of the agent's exclusive or non-exclusive territory in the contract, an agent might develop business plans that conflict directly with the exporter's broader strategy or with other agents. Precise territorial definitions avoid costly conflicts and clarify market responsibilities.
And who are they actually selling to? How are customers handled?
Point 4, customers. This involves the explicit identification of client groups or target markets. It must also be crystal clear who executes the final sale contracts. Is it the agent or the exporter directly?
Right.
For instance, if the exporter handles direct sales in the agent's designated territory, it must be explicitly stated if commission is still paid to the agent for those sales. Otherwise, disputes over earned commission are almost guaranteed.
What about the exporter's right to say no to an order an agent has secured? That seems essential for quality control or managing inventory.
That's point 5. Acceptance or rejection of orders. The agreement must clearly state whether the principal, the exporter, retains the right to accept or reject orders secured by the agent. This is absolutely essential for the exporter to maintain control over production schedules, pricing strategies, product availability, and their overall brand image. You don't want an agent committing you to a deal you can't fulfill or one that's unprofitable.
Good point. Payment of commission is always a sensitive topic in any sales relationship. What details need to be nailed down here?
Precisely. Point 6, payment of commission. Commission is revenue for the agent and a significant expense for the exporter, so the exact rate, usually a percentage, and the base upon which it's calculated. For example, invoice value or net realized proceeds after the exporter accepts the order must be explicitly defined.
Get specific.
Very specific. A particularly critical clause here for Indian exporters, as per our sources, is that the agent would be entitled to commission only after the receipt of proceeds in India.
Oh, okay. Only when the exporter gets paid.
Exactly. This offers crucial financial protection to the exporter against non-payment from the end buyer, ensuring the exporter is paid before they pay the agent.
Smart. And if, despite all this careful planning, things still go wrong and a dispute arises, how is that handled?
Point 7, settlement of disputes. In international trade, where most business is built on well-drafted contracts, the contract absolutely must have a clear clause for the mechanism for dispute settlement. Our sources highlight arbitration as the most acceptable solution for international disputes, being generally less expensive, quicker, and helping to maintain less strained relationships compared to traditional litigation. It's a strategic choice.
Arbitration over court, usually. Finally, what about the lifespan of the agreement? How are renewals and terminations handled?
Point 8. Renewal and termination. The contract should provide suitable clauses for the renewal of the agreement period upon expiry of the originally agreed term. Equally important are clear and unambiguous grounds for termination.
Why is that so important?
Well, this is vital because if the business does not perform as anticipated, the principal may desire to terminate the agent, and the agent may demand compensation for premature termination. Without these clear clauses, disputes over termination and compensation are almost inevitable, severely impacting both relationships and finances.
So the takeaway is,
The real takeaway here, it's that the devil is truly in the details. Without meticulously defined clauses, especially around commission payment, territory, and dispute resolution, exporters can find themselves in costly legal battles, losing not just money, but invaluable international relationships and market opportunities.
that distinction between principal and agent is clear, but an agent isn't always the same as a distributor, right? What are the key differences here that exporters need to be keenly aware of? This seems like a fundamental choice with very significant implications for an exporter's risk and control.
This comparison is absolutely fundamental for exporters, and it truly represents a fork-in-the-road decision. Choosing between an agency and a distributorship fundamentally alters your exposure to credit risk, your control over pricing, your relationship with the end customer, and your financial investment. These distinctions are critical to grasp.
Let's start with the most basic difference. Who actually owns the goods at any given point?
A title of goods. In an agency agreement, the title to the goods remains with the exporter, the principal, even if the goods are in the physical possession of the agent. The agent doesn't actually buy the goods.
Agent doesn't own them.
Right. In stark contrast with a distributorship, the distributor purchases the goods on their own account from the exporter, and so the title to the goods transfers directly to the distributor. This is a crucial difference that dictates risk and ownership throughout the supply chain.
Distributor buys and owns the goods. And what about the actual role they play in the sales process? Are they just order takers or do they handle the entire sale?
B. Scope of services. In an agency agreement, the agent primarily procures orders only. After obtaining the order, the exporter deals directly with the buyers for the sale, invoicing, and delivery.
Agent finds the customer, exporter sells.
Yes. In a distributorship, the goods are sold directly to the end buyers by the distributor, who acts as an independent reseller. The identity of the ultimate end buyers may not even be known to the exporter unless the distribution agreement specifically provides for it.
Distributor handles the whole sale. Who takes the financial hit if an end buyer doesn't pay? That's a huge consideration.
C. Credit terms. This is where the risk really diverges. In an agency agreement, all credit risks related to the end buyer are borne by the principal, the exporter. The agent isn't financially exposed if the end customer defaults.
Exporter bears the credit risk with an agent.
Correct. However, in a distributorship agreement, the distributor is solely responsible for credit risks, as they have already purchased the goods from the exporter. The exporter is paid by the distributor, regardless of whether the distributor collects from their customers.
Distributor bears the credit risk.
Okay, what about liability to other businesses or individuals? For example, if a product causes harm.
D. Third-party liability. In an agency agreement, the principal, the exporter, is often directly liable to third parties because the agent is legally acting on their behalf as an extension of their business.
Exporter liable for agent's actions. Often, yes. Conversely, a distributor is generally responsible for any third-party liabilities arising from their distribution and sales activities, as they are acting as an independent entity in their sales.
Distributor are liable for their own actions. And finally, who ultimately calls the shots? Who has control over the market and pricing?
Control. In an agency agreement, the principal, the exporter, typically enjoys absolute control over the business, pricing, and its relationship with the end buyers.
Exporter has more control with an agent.
Yes. With a distributorship, the principal's control is inherently weaker, as the distributor acts independently, buying and selling goods on their own account. In fact, if a distributor becomes powerful and commands a significant market share, they can even exercise substantial influence or even control over the exporter's market strategy in that territory.
Distributor can gain significant power.
Exactly. The moment the title to goods transfers fundamentally dictates who bears the financial risk and liability. If you're an exporter, Choosing between an agency and a distributorship fundamentally alters your exposure to credit risk, your control over pricing, and your direct relationship with the end customer. It's a truly strategic decision with profound legal and financial implications that needs careful consideration.
Beyond the agreements with partners, the product itself carries significant legal weight, right? Well, let's talk about trademarks, which are so vital for brand identity and recognition in a crowded global marketplace.
Absolutely. Trademarks are incredibly powerful legal tools and valuable assets for any business. They are defined as words, designs, or a combination of both, intended to perform marketing functions by clearly distinguishing goods or services from those of competitors.
Distinguishing feature.
Yes. The protection of a trademark is a defined legal process. Any person can apply for a trademark, and once the registering authority publishes the request, if there's no valid objection from others, approval for registration is given.
Are there any restrictions on what can't be trademarked? I imagine you can't just trademark something completely generic or a common word.
You're absolutely right. This is a key point to remember for what's not allowed. Names, surnames, geographical places, common numerals, and descriptive words are specifically not allowed as trademarks because they are not distinctive enough to uniquely identify a product or service.
Can't trademark London for clothes made in London?
Generally, no. It's
Oh,
too
Lord.
geographical. For example, you couldn't trademark Sweet Apple for a brand of fruit because it's too descriptive. But Apple Inc. can trademark its distinct logo and name for its technology products because it's unique enough in that context. Trademarks are valuable assets, offering brand recognition and legal protection, but they must be unique enough to truly differentiate a product or service in the market.
And what about product liability? That sounds like an extremely serious concern for any manufacturer or seller, especially when products cross international borders and different legal jurisdictions.
It is a massive concern, and one that can result in significant financial and reputational damage. Product liability is defined as the responsibility borne by manufacturers, distributors, and retailers for any consequential injuries or damages resulting from the products they make or sell. This liability can arise from several distinct bases.
What are those bases of liability?
First, there's liability in cases of negligence on the part of the manufacturer, where a defect or harm can be directly traced back to their lack of due care in design, manufacturing, or warning.
Okay, straightforward negligence.
Second, and this is a particularly significant point, there's the principle of strict liability. This was a landmark development, notably established by the U.S. Supreme Court in 1953. That's a key date and event in product liability law.
Strict liability, U.S. Supreme Court, 1953. What does it mean?
Under strict liability, manufacturers, distributors, or retailers can be held liable even without proof of negligence. This means liability can exist simply because a product is found to be defective and caused harm, irrespective of whether the seller acted carelessly.
So, even if a manufacturer took all reasonable precautions, they could still be liable if the product turns out to be defective. That's a huge burden. Could you give us a quick, simple example of how that might play out in practice?
Exactly. It significantly increases the burden on sellers and underscores the paramount importance of quality control at every stage. Imagine a toy manufacturer who rigorously tests every batch. Despite their best efforts, a faulty batch of toys reaches the market due to a microscopic material flaw undetectable by standard tests.
Right.
If a child is injured by a defect in that toy, under strict liability, the manufacturer could still be held responsible, even if they weren't negligent in their testing. The focus shifts from the manufacturer's conduct to the condition of the product.
Wow. Okay. Any other bases?
Third, liability can also stem from express or implied warranties. An express warranty is a specific promise made by a seller to a buyer, explicitly guaranteeing certain qualities, performance, or a specific lifespan.
Like a written guarantee.
Yes. An implied warranty, on the other hand, is an unwritten guarantee that a product or service should work as expected and is fit for its ordinary purpose. It comes into force automatically, in the absence of a communicated guarantee, ensuring basic consumer protection. The concept of strict liability, established by the U.S. Supreme Court in 1953, is truly a game changer because it fundamentally shifts the risk, significantly increasing the burden on all sellers and underscoring the absolute importance of robust quality control and clear, legally compliant warranties. #Shag 4.5 laws relating to packing and promotion.
Even how a product is packaged and advertised has significant legal implications internationally, far beyond just aesthetics or marketing appeal. This must vary widely from country to country.
That's absolutely right. International trade isn't just about the product itself, but also how it's presented, labeled, and communicated to consumers. Rules of advertisement, for instance, are very strict and highly varied across many countries.
Right.
What's considered an acceptable claim or marketing tactic in one market might be deemed illegal, misleading, or even culturally offensive in another. Beyond advertising, there are numerous other regulations concerning packaging standards. These often include mandatory declarations of gross and net weight, the precise date of manufacture and expiry, and essential precautions to be taken while using the product.
Lots of labeling requirements.
Exactly. This isn't just bureaucratic red tape. It's fundamentally about consumer protection, public safety, and fair trade practices. Exporters need to be incredibly diligent in localizing their packaging and promotional materials to comply with each target country's specific laws. Missteps here can lead to costly fines, product recalls that damage reputation, or even market exclusion. It's an often overlooked but utterly crucial legal dimension of international trade that requires meticulous attention. Hashtag 4.6 law relating to letters of credit.
Finally, connecting back to the ICC, how do letters of credit fit into this broader legal framework, especially regarding the crucial aspect of payment assurance for the exporter?
This is a cornerstone of international payment security, and a mechanism that directly addresses many of the risks we've discussed. Every exporter naturally wants to ensure payment before the physical possession and legal title to goods is passed on to the importer.
Naturally.
The opening and negotiation of letters of credit are governed by a specific, globally recognized, and highly standardized framework. This framework is the International Chamber of Commerce Brochure Number 500, famously entitled Uniform Customs and Practice for Documentary Credits, commonly known as UCP 500. That name, UCP 500, is a key identifier to remember.
UCP 500, so that's the rulebook for LCs.
Essentially, yes. And what's the core principle that makes LCs so reliable from a legal standpoint? How do banks manage to guarantee payment so effectively?
Yeah, how does that work?
The foundational principle, which is what gives the LC its immense power and reliability, is articulated in Article 3 of the General Provisions and Definitions within UCP 500. It explicitly states that credits, by their nature, are separate transactions from the sales or other contracts on which they may be based, and banks are in no way involved in the underlying contracts.
Banks only care about the documents, not the deal itself.
Precisely. This documentary independence is fundamental. It means the bank dealing with the letter of credit only looks at the documents presented. Do they match the LC's requirements precisely? Not the actual goods, their quality, or any dispute stemming from the underlying sales contract between the buyer and seller. This principle assures the exporter that if they present compliant documents, payment will be made, regardless of any disagreements over the goods themselves. It's why the LC is so trusted as a payment mechanism.
In an ideal world, every international contract would go smoothly, from agreement to payment. But in the real world, disputes happen. What are the common methods for settling these in international trade, and which one is generally preferred, especially for cross-border issues?
The choice of dispute resolution mechanism is, without exaggeration, one of the most critical clauses in any international contract. It can genuinely make the difference between a quick, amicable resolution that preserves business relationships and years of costly, frustrating legal battles that destroy them.
High stakes?
Very high. Our sources identify two main methods for dispute settlement: litigation and arbitration. Hashtag 5.1 limitations of litigation.
Litigation, or going to a traditional court, is what most people think of first when a dispute arises. But for international business, it seems to have some serious, inherent drawbacks that often make it unsuitable. What are those key limitations?
You're absolutely right. Litigation, particularly in an international context, is generally considered unsuitable due to a number of significant limitations. First, there's the notoriously slow process. Legal battles can drag on for years, sometimes even decades,
Years.
Wow.
incurring prohibitive costs and causing immense uncertainty for businesses whose very existence depends on timely outcomes. Second, there's the avoidable necessity of expert witnesses and other evidence, which can be incredibly complex and expensive to gather across different countries and legal traditions.
Logistical nightmare.
Third, it poses considerable inconvenience to the parties, requiring extensive travel, dealing with unfamiliar legal jurisdictions, and often navigating significant language barriers. Imagine fighting a case in a foreign court for 5 years. Your business might not even exist anymore by the time it's resolved.
True. What else?
Fourth, a public court case can result in significant adverse public image for the companies involved, potentially damaging their reputation and trust with customers and partners. Fifth, the inherently adversarial nature of litigation often leads to bitterness and the disruption of trade relationships, making future business between the parties virtually impossible.
Burns bridges.
Completely. Finally, navigating different laws and procedures in unfamiliar foreign legal systems adds another layer of complexity, unpredictability, and specialized legal costs. These 6 points clearly highlight why traditional litigation often fails to deliver practical or desirable outcomes in the international context, making alternative approaches far more attractive. Hashtag 5.2 Basic Advantages of Arbitration.
So given those formidable limitations of litigation, arbitration sounds like a much more appealing and preferred alternative. What makes it so much more suitable for resolving international trade disputes?
Arbitration offers significant advantages that directly address many of the drawbacks of litigation, making it a highly attractive, even strategic option for international businesses. First, there's its inherent quickness. Arbitration proceedings are generally much faster and more streamlined than traditional court litigation, leading to a more efficient and timely resolution, which is vital in business.
Vaster is definitely better.
Second, it's typically more inexpensive, helping businesses save substantially on legal fees and other associated costs compared to protracted court battles. Third, arbitration often promotes goodwill between parties, as it's usually less adversarial and more focused on finding a workable resolution, which can actually preserve long-term business relationships.
Less confrontational. And you have more control over the process, don't you? Including who actually makes the decision.
Exactly. Fourth, parties have the crucial choice of an appropriate arbitrator. This means they can select an expert in the specific field of the dispute, say, maritime law, petrochemicals, or intellectual property, who truly understands the technical nuances of the disagreement. This leads to more informed, commercially sensible, and fair outcomes.
An expert decides, not just a general judge.
Right. And fifth, and crucially for businesses dealing with sensitive information, arbitration proceedings offer paramount privacy. They are typically confidential, preventing sensitive business information, trade secrets, or brand image issues from becoming public knowledge. The ability to choose an arbitrator who is a genuine expert in your industry is a huge benefit, ensuring the decision maker truly understands the nuances of the dispute, leading to more informed and fair outcomes. And that privacy is crucial, especially for businesses where public disputes can damage reputation or reveal sensitive strategic information to competitors. Hashtag 5.3 How to Resolve and Settle Disputes.
So, if arbitration is the preferred method, how do you actually implement it, or other dispute resolution mechanisms, into a contract to ensure it's effective when the time comes? You don't want to be scrambling when a dispute has already flared up.
This underlines the absolute importance of foresight. You don't wait for a dispute to happen to figure out how to resolve it. That's like trying to build an emergency exit during a fire.
Good analogy.
The key is the inclusion of a future dispute clause in the contract itself. This clause is absolutely essential to pre-agree on the specific mechanism like arbitration that will be used to resolve any potential disagreements. This proactive step provides a clear, defined, and agreed-upon path for resolution, preventing further complications and escalating costs if a dispute arises. It's like having an escape plan pre-approved, ensuring that even if things go south, there's a defined, efficient path back to resolution, ideally through arbitration.
Put it in the contract up front. And once an arbitration award is made, how is it enforced, especially across international borders? What if one party is in India and the other is in, say, Europe?
That's a critical question for the efficacy of arbitration. India has a legal framework specifically for this. There is a specific law for enforcement of foreign awards in India, which provides the mechanism for legally enforcing arbitration decisions that have been made in other countries.
Okay, so foreign awards can be enforced in India.
Yes. Our sources also mention the specific procedure for enforcement in India for such awards, outlining the steps to take. Conversely, for arbitration awards made in India, there are often reciprocal arrangements for enforcement in foreign countries through international treaties and conventions. This ensures that these arbitration decisions hold legal weight globally, solidifying arbitration as a truly binding process with actionable outcomes, rather than just a discussion. All right, we've covered how to make a deal and how to resolve disputes if things go wrong. Now for perhaps the most critical part for any seller, getting paid. International trade has its own incredibly sensitive payment dynamics, often influenced by fierce competition and fluctuating risks. Indeed. International trade is not only highly competitive, but also incredibly sensitive when it comes to payment. The credit facilities that an exporter is willing to extend to importers can, many a time, genuinely tilt an importer's choice of exporter.
Offering better payment terms can win the deal.
It really can. This means offering flexible payment terms can be a powerful competitive advantage in winning deals. The extent of credit an exporter needs to extend, and thus the funds they need to finance the transaction, largely depends on the chosen terms of sale.
Right.
For instance, an exporter who has finalized the terms of sale on a CIF, cost, insurance, freight basis, requires more funds up front to finance the export transaction than on an FOB, free on board contract, especially if no advance payment is received from the importer.
Because CIF includes paying for freight and insurance up front.
Exactly. This difference between CIF and FOB vividly illustrates how the chosen Incoterm directly impacts the exporter's media financing needs and overall cash flow. A crucial point for any exporter is that export transactions are only deemed complete when the full export proceeds are completely received from the importer. Hashtag 6.1 factors determining payment terms in Indian regulations.
What influences which payment method is ultimately chosen? It can't be one size fits all, given the complexities of global trade, economic conditions, and trust levels.
You're absolutely right. Payment terms are determined by a host of interconnected factors. These include the specific exchange control regulations of both the exporters and importers' countries, the financial competence, stability, and reputation of the exporter themselves, any monopolistic conditions of the product being traded, meaning how unique or in demand it is, and above all, the relative bargaining strengths of the parties involved.
Bargaining power is key.
It often is. Each of these can significantly push negotiations towards different payment methods, often weighing security against flexibility.
And what about specific Indian regulations on this? Is there a hard deadline for when Indian exporters need to receive their money? We touched on this with FEMA.
Yes, for Indian exporters, there's that very clear and critical regulation under our exchange control laws, which is a key fact to remember. The full value of export proceeds must be received within a period of 6 months from the date of shipment.
6 months or 180 days, essentially.
Right. The 6-month rule is a hard deadline that is non-negotiable for Indian exporters. Any extension of this period requires the prior approval of the Reserve Bank of India, RBI, unless the exports are genuinely made on a deferred payment basis or the goods are sent on a consignment basis, which have their own specific rules. That 6-month rule from the RBI is absolutely central for Indian exporters. It's a direct deadline that profoundly influences the selection of payment methods and the credit terms they can offer to importers. Missing it can lead to severe penalties, so compliance is paramount. Now let's explore the 5 primary methods of receiving payment from overseas buyers mentioned in our sources.
5 methods. Okay, let's break them down. This sounds like the exporter's absolute dream scenario, right? Getting paid up front before even shipping the goods. It completely eliminates payment risk.
It absolutely is the most secure method from the exporter's perspective. This mode of payment carries no credit or transfer risk whatsoever for the exporter in executing the contract.
Zero risk for the seller.
Pretty much. It's ideal when the economic or political conditions in the importer's country are unstable, or there is no guarantee of payment receipt due to high perceived risks. This method is also commonly known as cash in advance.
Cash in advance?
It is without doubt the most secure method of payment for the exporter because the importer pays the full or significant amount of the payment before the goods are even shipped. Payment is usually made via straightforward, instant methods like wire transfer, credit card, or an escrow service.
Simple and safe for the seller, but
Sure.
probably not popular with buyers.
Exactly. This method completely eliminates the risk of non-payment for the exporter. It's the safest, but precisely because it puts the entire financial burden and risk on the buyer, it's also the least common in highly competitive markets. Buyers generally prefer to defer payment, so this usually only happens when the exporter has significant bargaining power, or the political or economic risk in the importer's country is exceptionally high.
When advance payment isn't an option, our sources point to documentary bills as the next best alternative, bringing banks into the picture to add a layer of security. How do these actually work?
When an exporter is unable to secure upfront payment from the importer, documentary bills indeed offer the next best alternative mode of payment in terms of risk mitigation. A documentary bill is essentially a bill of exchange, a formal order to pay, that is attached to a complete set of shipping documents for a consignment of goods.
Bill of exchange plus shipping docs.
Right. The purpose of this arrangement is to provide the bank, and thus the exporter, with collateral security for the payment of the bill as the documents represent title to the goods.
What kind of shipping documents are we talking about here? What's typically included in that package?
Our sources clarify that these critical shipping documents, which are essential components of the documentary bill, can include the bill of lading, which is the contract of carriage and receipt of goods, the commercial invoice detailing the goods and cost, a dock warrant if the goods are stored at the dock, and the insurance policy covering the shipment.
So bill of lading, invoice, dock warrant, insurance policy, those kinds of things.
Exactly. These documents collectively essentially represent the legal title to the goods. The mechanism is that these documents are routed through the bank, which acts as a trusted bridge between the exporter and importer. By controlling these shipping documents, the bank effectively controls the goods themselves until payment or acceptance, thereby mitigating risk without requiring full upfront payment from the buyer.
There are two main forms of documentary bills that specify when the importer gains access to these crucial documents: documents against payment and documents against acceptance. What are the key distinctions here, and what does each mean for the exporter's risk?
These two forms are critical distinctions and represent different levels of credit risk for the exporter. First, there's documents against payment, DP. Under this method, the exporter draws a sight bill on the importer.
Sight bill means pay immediately.
Yes, payment is due immediately upon presentation. The relative shipping documents, specified in the contracts, are handed over to the exporter's bank with strict instructions to deliver them to the importer only on payment. When the importer makes the payment, and only then, can they get the title to the goods and their physical possession. So no money, no goods.
DP, pay first, then get documents goods. Sounds quite secure for the exporter. And what about documents against acceptance? DA, this sounds like it involves extending credit.
In contrast with documents against acceptance, DA, the exporter draws a usance bill on the importer. A usance bill means there's a specified payment period, which may be anywhere from 30 to 180 days after the date of acceptance or shipment.
30 to 180 days, but can't exceed 180 for India, right?
Correct. It's absolutely crucial to remember that this period cannot exceed 180 days for Indian exporters due to the exchange control restrictions mandated by FEMA 1999, which requires export proceeds to be collected within that time frame. In the DA scenario, the documents are delivered to the importer upon them accepting the bill, meaning they sign a promise to pay later within the agreed usance period.
So DA, accept the promise to pay, get documents goods now, pay later.
Exactly. The buyer gets the goods by simply accepting the bill, promising future payment. DP is clearly stronger for the exporter, as the buyer cannot access the goods without paying. DA, however, involves a direct extension of credit. While more attractive to the buyer as it provides working capital, it's inherently riskier for the exporter. The 180-day limit for usance bills for Indian exporters under FEMA is a crucial legal constraint that influences the viability of such credit terms. Hashtag 6.3.2, collection, purchase, and discounting of bills.
How do banks facilitate these documentary bills for the exporter? Do they always just wait for the importer to pay, or can they help with the exporter's immediate cash flow needs?
Banks play a crucial facilitating role in two main ways. First, there's the collection of bill. This is where either a DP bill or a DA bill is sent to a correspondent bank in the importer's country for the explicit purpose of collecting the proceeds from the importer.
Bank acts like a collection agent.
Pretty much. In the case of a DA bill, the importer accepts the usance bill by writing accepted and signing the usance draft. The bank here acts purely as a collector, forwarding the funds once received.
But what if the exporter needs funds immediately, perhaps to cover production costs or other expenses, rather than waiting for the collection process?
That brings us to the second mechanism, the purchase or discounting of bill. When the exporter is in need of immediate funds, at the very time of handing over the documents to their bank, they can request their banker to purchase or discount the bill and allow the proceeds to be credited to their account.
Bank buys the bill.
Essentially, yes.
Yeah.
If it is a sight bill, like a DP, the bank typically purchases it, providing immediate funds. If it's a usance bill, like a DA, the bank discounts it, providing funds up front minus a discount fee. In both cases, payment is made to the exporter on presentation of the documents, providing them with immediate cash flow, albeit at a cost.
So they get paid sooner but less.
Correct. This mechanism provides vital flexibility for the exporter. If they need cash flow, they can essentially sell their bill to the bank, receiving payment up front. It's a common and essential financing tool in international trade, allowing businesses to bridge the gap between shipment and actual payment. Hashtag 6.3.3, consequences of non-payment and common risks.
What happens if, despite these mechanisms and the bank's involvement, the importer still fails to pay? What are the specific consequences for the exporter under DP and DA scenarios, which have different points of risk transfer?
The consequences vary significantly between DP and DA and starkly highlight the inherent risks of extending credit internationally. In the case of a DP bill, if the importer fails to make the payment upon presentation by the correspondent bank, the exporter retains legal ownership of the goods.
Okay, seller still owns the goods.
Yes, but they may incur substantial additional charges by way of warehouse fees, demurrage, and insurance costs at the port of destination, because the goods will be lying unclaimed. The exporter then faces the hassle and expense of trying to redirect or resell the goods.
Big headache, even if they own the goods. And what about the riskier DA bill, where the importer has already gained possession of the goods? That sounds like a much tougher situation for the exporter.
For a DA bill, the situation is indeed far more challenging and riskier for the exporter. The importer has already received the goods by simply accepting the bill, but then fails to make payment later when the usance bill matures.
Oh dear.
In this deeply problematic scenario, the exporter's primary recourse is to file a civil suit against the importer. This is a far more difficult, lengthy, and costly process to realize payment, especially when pursuing legal action in a foreign jurisdiction with different laws and procedures.
Nightmare scenario.
It can be. The consequences are stark. With a DA bill, the exporter loses possession of the goods and then has to chase payment legally, which can be incredibly difficult, often with low chances of full recovery. This highlights the inherent risks of extending credit internationally.
Are there common risks that apply to both DP and DA, perhaps external factors beyond the importer's control?
Yes. In both cases, documents against payment and documents against acceptance, there is a common and significant external risk called transfer risk.
Transfer risk.
That's right. The documentary credit under letters of credit, LC, is widely considered the gold standard for security in international trade. Its main attraction and a definite key takeaway is the near elimination of credit and payment risks for the exporter.
Bank guarantee, essential.
Essentially, yes. The exporter obtains payment from a bank rather than directly from the importer, largely insulating them from the importer's payment default or even the country's transfer risk. The method works like this. At the request of the importer, a bank makes an irrevocable commitment to make payment under certain specific documentary circumstances and up to a specified limit.
Okay.
The bank's promise to pay, which is independent of the underlying sales contract. Remember, UCP 500 is a powerful guarantee, reassuring the exporter that if they fulfill their documentary obligations, payment will be made. Hashtag tag 6.4.1 parties and documentary credits.
A letter of credit sounds quite complex, involving multiple financial institutions and precise steps. Who are all the players involved in making an LC work effectively?
Understanding the roles of the various parties is absolutely key to grasping how an LC functions as a secure payment mechanism. Our sources identify 7 distinct parties involved in a documentary credit, and this number, 7 parties, along with their roles, is an important set of facts to remember.
7 parties. Okay, who are they?
1. The importer, who is the applicant for the letter of credit. They initiate the process and instruct their bank. 2. The bank who issues the letter of credit, known as the issuing bank. This is typically the importer's bank, and it makes the payment commitment.
Importer and issuing bank.
3. The bank to whom the letter of credit is sent, typically in the exporter's country, which is the advising bank. Their role is to verify the LC's authenticity and inform the exporter. 4. The bank which adds its own confirmation or guarantee to the credit, known as the confirming bank.
Advising bank and confirming bank. What does confirming add?
This bank, usually located in the exporter's country, adds a crucial layer of security, guaranteeing payment, even if the issuing bank or its country faces financial or political issues. This significantly reduces the exporter's risk. Double guarantee. Okay, who else?
5. The bill of exchange itself, which is a key financial instrument within the LC framework, drawn by the exporter on the issuing or confirming bank. 6. The credit permits, which refers to the negotiating bank. This is the bank that examines the documents presented by the exporter and, if they are compliant, pays or negotiates with the exporter. They then forward the documents for reimbursement.
Bill of exchange and negotiating bank. And finally,
7. Finally, the exporter, for whose benefit the documentary credit is opened, who is called the beneficiary. They are the ultimate recipient of the payment.
the beneficiary. So importer, issuing bank, advising bank, confirming bank, bill of exchange, negotiating bank, and exporter beneficiary. 7 parties. Exactly. Understanding these 7 parties and their distinct roles is key. The confirming bank, for instance, truly adds another layer of robust guarantee, often in the exporter's own country, fundamentally reducing the exporter's risk exposure related to the issuing bank's country or financial standing. It's a complex but incredibly effective financial instrument when structured correctly. Tag 6.4.2 types of letter of credit.
And there isn't just one type of LC, but several, each with its own nuances and specific applications. Our sources list no fewer than 12. While we won't get bogged down in every single detail, let's highlight some of the truly foundational distinctions and the most impactful types you'll encounter.
Indeed, the sheer variety of LCs allows for tailoring to very specific trade scenarios and risk appetites. Understanding the core types is crucial for navigating trade finance.
What's most basic type, and then what about how flexible or rigid an LC can be? Can they be canceled?
Okay, 1. A documentary letter of credit is the generic term, simply specifying the various documents that are required to be submitted by the exporter to the importer's bank to get paid. 2. This leads directly to revocable and irrevocable credit. A revocable LC means the issuing bank can change or cancel the terms and conditions without prior notice to the beneficiary.
Doesn't sound very secure.
It isn't. As you can imagine, this offers very little security to the exporter and is rarely used. An irrevocable LC, which is the common and preferred type, cannot be canceled or modified without the seller's explicit consent. This provides much greater security and peace of mind to the exporter.
Irrevocable is standard. What about the negotiating bank's risk? Can they come back to the exporter if something goes wrong down the line?
3. Then there's with recourse or without recourse LC. Under a with recourse letter of credit, the negotiating bank can, in fact, make the exporter liable in case of default in payment by the opening bank or the importer.
Exporter might still be on the hook?
Yes. However, a without recourse letter of credit means the negotiating bank has no recourse to the exporter. They bear the risk of the issuing bank or importer defaulting. This is significant protection for the exporter.
Without recourse is better for the exporter. You mentioned confirming banks earlier as adding a layer of security. How does that create a distinct type of LC?
4. That's the confirmed and unconfirmed letter of credit. A confirmed letter of credit is where the issuing bank and a separate confirming bank both guarantee payment to the exporter. This is a powerful dual guarantee, often used when the exporter has concerns about the issuing bank's ability to pay or the political economic stability of the importer's country.
Confirmed. Double guarantee.
Right. An unconfirmed letter of credit, conversely, is a payment guarantee issued by a bank to an exporter, but without confirmation from another bank, meaning the guarantee comes solely from the issuing bank. More risk if the issuing bank or country is unstable.
Can the benefits of an LC be passed on to another party, say, if the exporter is sourcing components from multiple suppliers?
5. That's the transferable and non-transferable letter of credit. A transferable letter of credit allows the first beneficiary, the exporter, to transfer some or all of the credit to a secondary beneficiary, often a supplier or manufacturer, to ensure timely payment down the supply chain. This is vital for complex supply chains.
Useful for intermediaries?
Yes. A non-transferable letter of credit prevents the transfer of its benefits to any other party. It is issued to a specific beneficiary, usually the seller in a trade deal. While the credit itself can't be transferred, the beneficiary can usually still assign the proceeds they're entitled to.
Can assign the money, but not the credit itself. What if there are multiple ongoing shipments involved with the same buyer and seller? Do you need a new LC every time?
6. Not necessarily. We have fixed and revolving letter of credit. A fixed letter of credit is for a fixed period and amount, and simply expires if the credit is fully used or the time runs out. A revolving LC, however, is a single LC that can cover multiple shipments between the same buyer and seller, automatically refreshing after each use or period up to a certain predefined limit. It's great for ongoing relationships.
Revolving LC saves paperwork for regular shipments. Can the exporter choose which bank to present documents to for payment?
7. This is covered by freely negotiable and restricted letter of credit. A freely negotiable LC is a type of letter of credit that allows the beneficiary to present documents to any financial institution for payment collection and examination, offering maximum flexibility.
Any bank.
Yes. A restricted letter of credit, however, limits the redemption of credit by specifying a particular bank to pay, accept, or negotiate the LC.
Only one specific bank. Okay, now these red clause and green clause LCs sound almost like something out of a spy novel. What's the story behind these and why are they so unique?
They are indeed intriguing and unique, specifically because they offer a financing component before shipment, which is a game changer for cash flow. 8. A red clause letter of credit is one that authorizes the exporter to avail pre-shipment finance, meaning an advance payment on the strength of the credit itself.
Finance before shipping. Wow.
Yes, the clause is literally printed or typed in red ink on the document to make it highly noticeable and alert the banks to this prepayment authorization.
Hence, red clause. Makes sense. And green.
A green clause letter of credit, in addition to providing pre-shipment finance, goes a step further and allows for storage facilities at the port of shipment to the exporter, the costs of which are covered by an advance from the opening bank. This clause is typed or printed in green ink.
Green covers storage, too. These sound amazing for exporters needing working capital.
They really are. These are fascinating because they offer a vital cash flow solution for the exporter before the goods even leave their premises.
Okay, quickly. What about the last few? Back-to-back, assignable, deferred, standby.
Right. 9. A back-to-back letter of credit refers to a pair of LCs used when an intermediary is involved, but a transferable LC isn't suitable. The first LC from the ultimate buyer secures the intermediary, who then uses it as collateral to open a second, separate LC for their supplier. 10. Assignable and non-assignable letter of credit is similar to transferable, non-transferable. An assignable LC can be transferred to a third party. A non-assignable LC can't, but again, proceeds can usually be assigned. 11. Deferred period of credit is simply when the supplier provides credit after the supply of goods. Payment is due later. 12. Finally, a standby credit. This is unique, acting more like a guarantee. It's the buyer's bank guaranteeing payment if the buyer doesn't pay. It acts as a secondary payment method, triggered only if the holder defaults. Standby kicks in only if the buyer fails. Exactly. The distinctions between with recourse and without recourse, LCs, are critical for the exporter's financial security. A without recourse LC means the negotiating bank bears the risk of the issuing bank's default, a significant protection for the exporter. And those red clause and green clause LCs are truly fascinating because they provide pre-shipment financing literally in red or green ink directly from the LC, offering a vital cash flow solution for the exporter before the goods even leave their premises. This entire suite of LC types showcases the remarkable flexibility and risk mitigation that can be built into international payment systems.
This sounds like the most straightforward but perhaps riskiest method for the exporter. Goods shipped first, payment later. No bank guarantees, just trust.
You're right. From the exporter's perspective, this carries the highest risk. An open account transaction is a sale where the goods are shipped and delivered before payment is due. This is essentially extending direct credit to the buyer.
Pure credit sale.
Yes. Payment terms are typically specified in periods of 30, 60, or 90 days from the date of shipment or delivery. Those are key durations to note. A periodic payment settlement, or structured settlement, involves a series of future payments made according to a prearranged schedule.
30, 60, 90 days are typical.
Very typical. This is fundamentally selling on credit, where the buyer gets the goods first. It's highly advantageous for the importer as it frees up their working capital and minimizes their upfront financial commitment. However, it exposes the exporter to significant credit risk. It's usually reserved for highly trusted, long-standing relationships, or in very competitive markets where the exporter has little bargaining power, making it an offer they almost have to make to secure the deal.
Finally, a consignment basis shipment. What's the arrangement here, and who benefits most from this approach, particularly for new products or markets?
Shipment on a consignment basis refers to a specific business arrangement, where a seller, known as the consignor, ships goods to a buyer or consignee without receiving immediate payment.
Seller ships, but doesn't get paid yet.
Correct. Instead, the buyer, the consignee, only pays for the goods after they have successfully sold them to a third party. So payment to the original exporter is directly contingent on the ultimate sale of the goods.
That seems like a significant risk for the consignor, the original seller, holding all that inventory risk. Why would they agree to that kind of arrangement?
While it does shift the inventory and payment risk to the consignor, there are significant advantages, particularly for the consignee, and strategic benefits for the consignor too. These advantages are important to understand.
Okay, what are the upsides?
First, it offers reduced financial risk for the consignee, as they don't have to purchase the goods up front and commit capital until they actually make a sale to an end customer. Second, for the consignor, it provides increased sales potential, as it opens up new distribution channels and makes it much easier for potential buyers to take on the product without upfront capital investment.
Easier for the buyer to say yes.
Exactly. Third, it offers an excellent opportunity for the consignee to test market demand for the product without making a significant upfront purchase investment. This is a great strategic approach for market entry or for launching new products, allowing the consignee to gauge consumer interest without committing capital.
Good for testing the waters.
Precisely. While the consignor bears the inventory risk until the final sale is made, it's a win-win for market exploration and expanding reach. Hashtag outro.
Wow, what an absolutely fascinating deep dive into the intricate world of international business contracts and payment terms. From the foundational legal definitions to the complex dance of Incoterms and the multitude of payment options, it's crystal clear that international trade is a masterclass in calculated risk management and incredibly precise, unambiguous communication. We've seen how a single missing clause, a misunderstanding of a technical term, or a misstep in a payment timeline could literally unravel an entire high-value deal.
Indeed. We've covered crucial dates, like the Indian Contract Act of 1872 and the FTDR Act of 1992, vital numbers like the 180-day rule for export proceeds and the 12.5% commission limit under FEMA,
Right, those key numbers.
and deciphered the full forms of terms like Incoterms, International Commercial Terms, and UCP, Uniform Customs and Practice for Documentary Credits. And we've highlighted the crucial distinctions between different types of LCs, especially the red and green clause LCs for pre-shipment finance, and the immense significance of the UCP 500 as the Bible to bankers. These are all key pieces of knowledge for anyone involved in global commerce.
You now have a truly fantastic overview of these crucial elements, from understanding precisely who bears the risk of goods on the ship, to how a bank can effectively guarantee payment, and why arbitration is almost always preferred over litigation for international disputes. It's all about minimizing surprises, building certainty, and having a clear roadmap in a world that's inherently unpredictable.
Exactly. For you, the curious learner, the key takeaway is that robust contracts and well-chosen payment terms aren't just legal necessities or administrative hurdles. They are, in fact, strategic tools for global business success.
Strategic tools.
Absolutely. They build trust, effectively manage risk, and ultimately facilitate the smooth, reliable flow of goods and money across borders. Mastering these concepts provides a significant competitive edge.
So here's a final thought for you to ponder, something to mull over as you think about the future of global commerce. Considering the constant evolution of global trade, with new technologies like blockchain and AI emerging, alongside ever-shifting geopolitical landscapes, what do you think will be the next big innovation in international contract law or payment security?
Interesting question.
What new mechanism might one day make even our sophisticated letters of credit seem old-fashioned? What will be the next Bible to bankers that transforms how we do business globally?
Food for thought.
Thanks for joining us on this deep dive. We hope you feel more informed, more confident, and truly ready to tackle the complexities and opportunities of international business. Until next time.